Well, good evening, everyone. Welcome to the nighttime normal edition of Justice Served TV. I'm Linda Kenney Baden. As you know, I will not have my normal co-host, Michael Bryan, who drove up to Canton yesterday, went to Dedham to the courthouse where the Karen Reed hearing was there. We have some footage from him outside the courtroom. And then we will have a special co-host on the show in a little bit. That'll be Neil Rockind. Rockind, actually, his name is. I call him Neil Rockind. Okay, I've given him a nickname. He has so many. Neil, let's see, Rockweiler, Neil, the great attorney. You know who I'm talking about. But anyhow, we had so many questions that I thought we'd start early. And before we get into it, because I'm going to show you some clips and all, but I thought I'd change this a little bit because I want to say hi to some of you while we wait for Neil. And Kathleen Heather. Kathleen, I think, are you new to this channel? I see your questions. Thank you very much for calling me lovely. I appreciate it. You are not an annoying commenter. Okay. I've been on Court TV. I used to be on Court TV a lot. Law and Crime was where I was. That's where I was an anchor. But I was on Julie Grant's show 2 weeks ago when we broke that exclusive. Actually, we broke 3 exclusives on the ASAP Rocky case. Small little us. I guess some people couldn't take it because we turned out to be right, I believe, on all of them. But there was a defense attorney who you named. I do not know that person. Okay, I don't never heard of him. That doesn't mean he's not a good defense attorney. That doesn't mean he's not a good attorney. But to explain, he said that what do you want to know? What do you think of the comments? And this attorney said, let's not mince the words. They lied to the court. So we're going to bring Neil on in just a minute. As soon as I finish with these comments, let's not mince words. They lied to the court. They lied to the jury. I am not sure I would say that. And, you know, in this day and age of defamation, I think you got to be a little careful here. All of their credibility is now affected by the stupidity of not saying, yeah, we paid them. But they didn't pay them, okay? That's the point. And we're going to go through this chronology with Neil. And then he says, well, the problem is that Alan Jackson is now a material witness and subject of a fraud. Let's not mince words. A public record crime in 50 states. Oh, give me a break. You want to come on this show? We'll have a great debate. The motion, the filing of that motion, Brennan mentioned at the end of the day where Yannetti and Jackson signed it. I guess it goes to say, you say that you don't see the Massachusetts Supreme Court keeping if the judge removes his pro hoc vice. Well, if the judge removes a pro hoc vice, usually the higher courts will agree to it just because a pro hoc vice is just so easy actually to remove. You don't have many rights in another state court once the pro hoc is granted for one case. But I will say to you, and we'll have this discussion with Neil when we go through, because I have the whole timeline, because we have great producers, Dizzy and Missy, who did the whole timeline of ARCA. I will say to you, my view of that view is poppycock, okay, that he committed a crime, okay? Now, is there some issues now going to be with credibility because the witnesses are going to be asked about being paid? But I think it's easily explained. But we'll see what Neil thinks when he gets on. But evening, yes, to making a count. Evening, Shy Gal 8. Evening, Law Nerd Amber. Evening, everybody making a count. Oasis Cat. I mean, I can't keep up with you. Thank you for saying you tell him. So let me, with now not much ado, because you know I give it to you straight. If I, and I love Alan Jackson. He loves me. All right. But I think that would be like people calling me because if I didn't give a discovery sense over, and we always have discovery fights in courts in a pro hoc that all of a sudden I'm subject to a crime. Come on. All right. Come on. All right. Let's give us a break. Let's deal with this, and we'll deal with this, and we'll see. Okay, so Neil Rockind, Neil Rockweiler. Here you are. We have a full plate here. Everybody's here, I think, to see you. They're so excited that we. And I'm going to cry right now as I've had allergies all day. Excuse me. As I introduce you. Oh my God, Neil's on with me and I'm crying. All right. So what I want to start with is a bunch of things. First, I'd like to start with
Big Girls
Don't
Cry.
You know,
That's
Bob
right.
Dylan. Excuse me while I go underneath and blow my nose out. This is
okay.
what happens. What happens when you have allergies and you're doing a
That's
live
right.
show,
That's
guys.
right.
I mean, we're real. Okay, we're absolutely real. here. But one of the things that I want to start with, because Michael Bryan, as you know, drove up. We've been covering this case live in Canton. This is exactly one of the reasons we bought our Starlink for, so we could be live everywhere. So, by the way, if you love Michael Bryan, who's not on tonight, all right, give him a hint that you love him too, not just Neil and I, by hitting that like button, that subscribe button, that share button, and tell everybody that we're here. You see everybody saying, hi, Neil, hi, Neil, hi, Neil. So he was,
hey, what's up?
Hey. Yeah, we had Bob Dylan on our show yesterday. Not Bob Dylan in reality, but we had Subterranean Homesick Blues on because someone said about the wind blowing, and I said, yeah, but you know which way the wind blows.
That's
and I asked our viewers to find it, our chatters to find it, and they found it right away. All right,
love it.
So because Michael Bryan and we're on there 8 hours yesterday, almost with all of you, was up there. I'd like to show you a clip when Alan Jackson and the team came out of the court. And the reason I want to show that to you is because he talked about how normally they're very chatty when they come out of the courthouse. But today or yesterday, they weren't so chatty. You'll hear Michael Bryan, you'll hear his voice asking Alan Jackson a couple of questions. So let's listen to that.
Mr. Jackson, how do you think it went?
Alan, any comments about the federal investigation being over?
Come on, let's go, guys. Walk so no one trips. Good job, guys.
Mr. Jackson, what do you expect the court to do?
About today.
Any thoughts on a remedy?
You got me?
Yeah, I got you. My hand's on your desk.
Are you worried about see if you can see the stuff. You're good. All right, Alessi. You're good. You're good.
They're talking a lot, Alan.
You're not going to talk.
I tried.
You're a rock star.
Good job, guys. Woo! Got this.
How do you think it went there, Mr. Alessi?
Good job, Mr.
Anything you want to say
Alessi.
after today?
Now, listen to that. The only reporter's voice you're going to hear out there asking questions is our reporter, our host, the Justice Serve T. You heard it all there, right? Didn't you, Neil?
That's
you heard
right.
Michael there asking those questions.
Right.
So that's a good starting point to what do you think before we even go through it, what do you think the judge is going to do? Give us, you're testifying in court, all right, co-host, all right? And so my co-host is testifying in court. What do you think she's going to do? And if she does anything, is there some kind of remedy that she's going to impose to the state?
I was nervous. In fact, I texted you while we were sort of preparing for today. I've made pretty good calls on verdicts in the past cases that we've talked about and covered together. I think pro hoc vice is a privilege, and I think that the judge, this is just my take, I think the judge appears to have a disdain for Alan Jackson. Maybe she doesn't, but she appears to have a disdain for Alan Jackson. I didn't like when he stood up and there was a discussion, something that people didn't talk about yesterday, when the judge went around and said, you don't have to say anything if you don't want to, but if you do, I'm willing to hear from you. I sort of held my breath. Yannetti stood up and said, I'm fine. I agree with everything that Mr. Alessi said. Then went to Alan Jackson and AJ stood up and, I'm sure some of us wished he had just said, I agree with everything, but then he added, in my mind, during that sidebar, I'm sure the court remembers it better. And she goes, I remember it. I've replayed it. I've thought about it several times. I paused right there, which tells me that she has thought about his statement that I have nothing to share with that they have everything that we have. I'm going to say that I don't think that she should disqualify or that she should remove Alan Jackson from the case. I don't think that she should remove his pro hac vice status. I think that there's a double standard at play that we witnessed at play all the time, which will lead nicely into our discussion about the Glossip case and the Supreme Court decision that reversed a death penalty case out of all places, Oklahoma, where there's a double standard between prosecutors and defense lawyers. Prosecutors and prosecutor witnesses get to say things and then be corrected, or say things and be discredited, say things and then be impeached, say things and then proven to be wrong. The defense and the defendant and defense experts, and particularly defense lawyers, as you know, because you are one, Linda, as am I, we say something and we have to be held to a T. Like if Mr. Rockind, you said big T, you didn't say small t. And then we have to, so we live with, in essence, we have to be 100% right.
310% right.
110% correct and accurate and precise. And if prosecutors get the chance to be 25 or 30% or 50% precise and accurate, and they get to come back and correct it and say, well, I was doing my best, Judge, I'm an overworked state prosecutor. I didn't like the fact that this argument about Alan Jackson and his ability to remain on the case, and again, we're assuming that that's one of the potential remedies, that I didn't like that it came down to whether what he had in his mind and what Lisa Little had in her mind at the time that the discovery was disclosed, and that when Alan Jackson made that statement. I didn't like that. I just think that's too fine that's just too fine a point for someone's Sixth Amendment right to have to rest on. So that's one. I'm going to go on a limb and say that I don't think that she should remove Alan Jackson from the case, but I fear that she will remove his pro hac vice status.
Which removes him from the case.
Which would remove him from the case. That is my concern. I thought that this whole issue ends up, in my opinion, being a much ado about nothing. It is much ado about nothing. It ends up being, in we lawyers who have tried cases with a lot of, and I don't think that Alan Jackson should be removed. I don't think he did anything improper. I don't think in the context of preparing a massive case like this, that it is fair to hold a lawyer to the standard where he says, we disclose, we have what they have what we have. And that somehow thinking that they don't have, that the prosecutors don't have the very same basic information that Alan Jackson and the defense had. Both the ARCA experts were available to both. The reports were available to both. I think that a person's Sixth Amendment right to have the lawyer of their choice trumps everything. I think it should trump everything. I think that, and to
we're not getting political here.
We're not getting political. Not talking about Trump, not saying Trump. I'm not using Donald Trump. That is, when I say Trumps, I mean that above all, the prosecution, a person has a Sixth Amendment right to his or her choice of counsel. I fear that the judge, when Alan Jackson stood up, I feared just when he said, I didn't have in my mind the issue of payment. I had in my mind, or the question about payment. I didn't have that in my mind. And my concern is that the judge could hang her head on that. Remember, pro hac vice is a privilege.
Right.
And my fear is that, and you've been, I'm sure, Linda, you've been admitted pro hac vice, I'm sure, in many states.
Many states. I've been going through many states, right.
But this is, we're now in a place where I think the judge that she could. I think that she could issue some sanction. I'm going to go back one step if I could.
No, absolutely, and then we'll go
the
forward.
Prosecutor. I thought that the breathless. I need to take a break. We need to adjourn this hearing. I can't continue, which we all heard of last week. And Mr. Jackson, you can appear by Zoom if you want. I thought all of that was unnecessary. I thought that was very disappointing. It was the height of judicial she may claim that it showed that she has the temperament of a judge to preside over these significant weighty issues, but I thought that it was quite the opposite. And I'll give you an example.
That's when she said that She adjourned because she had a grave concern. Right?
That has grave
Grave concern.
concerns.
I have a grave concern. Right.
And this could presume grave concern for the defense and defense counsel. And I want you to, your audience should our listeners should be wondering, when someone does that, do you want that person's finger on the button of the nuclear football? Like, do you want that person that is so capable in that particular moment of going hitting, going to the nuclear option? Because once you sort of make those comments, you put everybody on the defensive. And she didn't have the full story. And I don't think that I thought that 99% of what the state raised in its motion to try to disqualify the ARCA experts and to disqualify Alan Jackson as pro hoc vice, or to seek sanctions at least, I thought that most of that was much ado about nothing. And I think in a big case, it is possible for things to end up being lost. You prepared significant, massive cases, Linda.
Right.
I know you
Right.
have.
Right.
And it's possible on day one, you're in the middle of a trial. Did you turn over your blah, 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 exhibit number, a triple X?
We had something like 30,000 exhibits in the Spectre case, and I think my co-counsel, who was responsible, because you assign one person to do discovery, right, and that kind of that, and to get the missed turning over like one document or something, and he got reamed for it. But they weren't saying that it was
and you're doing your best, anybody. And you're, what would the better answer, I guess, in hindsight have been, Judge? I'm assuming that they have everything that I have, but if you'd like, we can double and triple check. We can stop the trial for a minute. We can go back and double and triple check. That's one. Two, I think it is really, I can't stand hearing the state and the state's attorney constantly play, harp on that they have the right to we have the right to fair trial. We have the right to not be surprised. We have the right to not. I detest hearing that. I know that state courts say that prosecutors and the state has the right to a fair trial, but look, in the end, if the party that lost had to designate a person to go to prison, so okay, state, who's your prison eligible responsible party? Because we know in the Karen Reed case, it's Karen Reed. So on the state's behalf, which one of you goes to prison? Now, if you want to put prison up against prison, someone goes to prison if the state loses, fine, we agree. Then one of you is in jeopardy, just as Karen Reed's in jeopardy. So you know what? Yeah, that person has the ability to go to prison if you lose. Well, let's make the stakes equal. But it's not. We know it's not that way. Right. It's never going to be that way.
Right. And you saw the late discovery they were giving recently.
It happens all the
time. But they were giving it. And why wasn't that given before the first trial?
It happens in small cases. It happens in big cases
all the time. And the judges.
How many cases I've had where the prosecutor walks in, oh, by the way, I just got this from the lab, and you're like, you just got what from the lab? And
right.
and I've got a whole, and I'm trying to balance 15 things. Trying to get ready for voir dire. We're trying to get ready to pick a jury. I got the judge's clerk asking for jury instructions. I got my clerk or my associate doing X, Y, Z. It could be on a minor case too. I don't mean minor for the accused, but just in terms of the enormity of the issues. And you're looking at the jurors over there, and the judge is like, I want to start promptly at 8:30 to take advantage of our time.
And there they are. We're not waiting.
Drop something on my desk and says, "You have any objection to this?" Or like, what is it? Oh, we found the chain of custody documents that you've been arguing, that we didn't have. And do I have an objection to it? Yeah, I have an objection to it. Judge, I need to talk to you at sidebar. Well, we're going to start with the jury trial, and then we can address this issue later. And now you've got to deal with something else. And if we drop that on the prosecutor in the middle of a trial, you know what happens? The prosecutor,
we're gone.
Everything stops.
Yeah.
Oh, hey, whoa. These horrible defense lawyers have just dropped a critical piece of evidence on the state, So, yeah, and I think Alan Jackson, I have found by and large him to be a pretty, I haven't seen his ethics, issues, but he seemed to be pretty straightforward and a pretty ethical guy. Like all of us lawyers, we get close to the line. But and what would the advantage have been? I know that they articulated that the ARCA experts had not been paid, or that they didn't have advance notice any more than the state about their opinions. But what else? I mean, the state could have called them and said, "Hey, what's your opinion? What are you going to say? What issues?" And the state just chose not to.
Yeah, no, I talked about this constantly about how it goes. And remember ASAP Rocky, where John Lewin, of all people, comes in. They've got a report that was made last year. The defense is opening. Everything's there. And oh, by the way, we found this 25-page report. We just got it, okay? How did that get lost, right? And and the judge says, well, I'll
Mr.
pay
Jackson,
for an expert.
And how about this? As a lawyer, when someone says to a client of ours, Mr. Smith, a judge, you don't have to say anything in response to the allegation that you violated the conditions of your bond, but I'm willing to hear you out. Right. And all of us lawyers, we start to think, God, I hope I wore extra antiperspirant today because this is going to get dicey. Right. And when she asked Alan Jackson and then Lisa Little, I felt terrible for her. I
never even really heard her name until yesterday.
No, and I felt like, no, I have shades of Carl Douglas, who I love, by the way.
I love Carl Douglas too. He when I was inspector, he came. First of all, he's wonderful. I've met him, a number of times,
yes.
and he was around. Excuse me, my wire is showing now today too.
That's okay.
All right. No, but it happens. But what I want to do before we go into seeing the rest of the stuff in court, I do want to give a shout out before we go further, and that is to probably one of the most important people in the courtroom. And there was discussion about transcripts. Do we have that shout out? My shout out from yesterday to the court reporter, Missy. Hold on a second now. That's actually a still, okay? And yesterday I gave her a shout out because her name was mentioned. That is Nancy M. King. She's one of the finest court reporters in Massachusetts. She's one of the few left that can speak into the cone, right? The cone, and listen, just like she's in the UN. Listen in one ear, and then out comes what she is hearing into the cone. And it's a skill that is
remarkable skill.
It's a remarkable skill. I know there's been a thing in Massachusetts for years to try to get rid of court reporters, but they assign her to all the major cases. She was in our Hernandez case. She is fabulous, fabulosito, is all I can say about her.
I had a case with an interpreter who did this.
That's right.
She sat at the end, and my client didn't speak any English, and she was so afraid of the accused in the case that she wore sunglasses. And I felt like we were like, I hate to say like in the Nuremberg trial, but she's talking to him, he's listening and like trying to, and she's interpreting, and we're all at the end, and the judge is like, I can't hear over the interpreter. And those court reporters, I don't know how they do it, but
I don't know how they do it either. The interpreter is the same way in the UN. There's a school in Monterey where they're all taught how they, listen in one language and say out in another language, and it's constant. And then she's basically doing the same thing, only it's with, she's right now she's hearing English, but it's, it's us attorneys, we talk over each other.
Your perspective, Linda, is so unique because you've actually, Alan Jackson. You've actually we fought
like
up
hell
against Alan Jackson,
right?
And you've also been involved in cases in Massachusetts. So, I mean, that's a pretty unique perspective. What do you think the judge is going to do?
Well,
I'm just here.
Let's go through it.
And then in Michigan. So
I'm going to give you my opinion after we go through some of this, because I kind of said what I thought she should do, but what I'm worried what she's going to do. And moreover, usually Judge Kenney doesn't issue an opinion from the bench, but then 4:30 in the afternoon, you get the opinion that clearly she had prepared, right? So yesterday we all looking at, and of course the hearing went late, nothing today. Today, just before we got on the air, I said, well, I better check just to make sure I'm not missing anything. So it sounds like she is writing an opinion. So let me give you what I said yesterday, what I think she should do if she is
And there's
concerned.
a new defense motion that was filed today, right?
I saw there was a new one. I haven't had a chance to read it, but I may
I
let
think
you
it's
talk
sealed,
about it.
so we won't see it yet.
Oh,
Yeah.
is that what it is? It's sealed.
Yeah.
Oh,
Yeah.
okay. All right.
Yeah.
Unfortunately, I was out doing some actual work this afternoon. It's one of those things. Things happen, and thank God for Missy and Dizzy getting all this together as I'm, wildly texting them all day. But one of the things if she wants to do something, what she could do is something almost like Mark Arnold does. Say, look, I'm not going to rule on this right now. I'm going to wait until after the trial and we'll discuss it then if I have any sanctions, right? But don't do anything on it. She could do that because one of the things that Brennan said, well, this gives him an opportunity to do things further and be unethical further all the way through the trial. So, there's ways to deal with that if that's what she feels, all right?
Mhm.
But I said yes. This is what I said yesterday, and we can go through it. I said, look, you get somebody in and you send out a retainer because you're going to want to talk to them. You're going to want them under attorney-client privilege at that point, right? It doesn't even necessarily mean it was a retainer for payment. He said something about we'll discuss the terms later, right? And then 2 days later, and we'll talk about this in the timeline, there was a pause. The Fed said no, and the Feds were still paying. We're still paying them, right? All the way through. So nothing happens. Why do you need him to bother to turn that over if it was just for attorney-client privilege issues, right? And then there was a pause, and then after the trial ends, they get a bill. Now, do you go back when you already have a hung jury and say, "Oh, by the way, I just got this bill"? No, you give it in the next trial, which is what they did, and then you pay. And of course, you're going to pay it. If I'm Alan Jackson and the defense team, I'm paying it right away because I have a hung jury. The prosecution said right then, they were retrying Karen Reed, I want these witnesses back. But then I give it over to the prosecution in discovery. The prosecution says to the judge initially that he didn't get it from them, right? He had to wait until to get it from the Feds, which was not true. It was not true. Now, he corrected it a few minutes later, but by then, social media had gone crazy. She had gone crazy.
And after the judge was breathless, right? Exactly.
Right, and that's when the judge was breathless. And he had turned it over before the next trial. Now, can you still say that? Sure. They were paid by the federal government. They were hired by the government again and again. They were talked to by the government again and again, the federal government. And they issued their opinions when they were spoken to, right? So the fact that he then submits an outline later on, oh, give me a break. I ignore those all the time. Here's my questions that I want you to ask me. Big deal. But why don't we listen to a little bit of?
I don't think that's unusual. I want people to understand it.
Right. They send them. They send them whether you want them or not.
And you get them sometimes where they want to go through their credentials, and you read this and you're like, well, I'm not doing it this way. You know what I mean?
Right.
But
right.
This is how I normally.
Yesterday.
Yeah, they're nervous. I mean, these, and I thought Alessi did a very good job of explaining that these experts are nervous when they want to know when they get up there. They're not used to getting up there and being surprised by the direct exam.
Right, which is what happens. So he says this stuff, and just like you and I, we just ignore that stuff. We not even do. And usually, if they're your expert,
the jurors in my cases, I'm like, look, let me just tell you, the direct examination, by the time the prosecutors get done questioning their witnesses, I just want to let you know, I know what they're going to say. I know what the prosecutor's questions are going to be. I know what the prosecutor's witnesses are going to say. Want to know why? Because it's not a surprise to them.
Right.
But they've done this. And by the time they do it, there's a dance that they've already done. So let me just tell you, it's in a way, it's sort of rehearsed. The test is not whether the witness says what they say on direct examination. I'm telling you, you can put your notebooks down on direct. The question is whether or not on cross, that's where a witness's true test is borne out, the true test of their reliability. Here's the thing for this expert, though. In this case, they didn't fully know what was going to be put to them
right.
direct by the defense.
I don't think I've been in that situation where I've had, or been able to have to deal with an expert that I've never put on the stand or talked to in terms of prepping them. Because what do I preach? Prep.
Right. Exactly.
Right. Anyhow, so let's listen to a little bit of Alessi's argument. Wissy, let's listen to that. It's a little bit, about a minute and a half.
Because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts. And because of the stakes here, I am going to go through it, hopefully efficaciously and efficiently, but it's going to have to be methodically.
Okay. So, I mean, I thought he, you know, LSC was brilliant. I didn't know anything about him beforehand. I'm wondering whether they're bringing in somebody from New York to argue like the law and things like that. And it seems to me that I'm not sure I'd put him in front of a jury, but I think in terms of the argument, he was, you know, he laid it out. And when she asked him, well, what about the outline? Was that turned over? And we'll talk about when Jackson received that. And he answered her, no, it was not turned over before trial. He didn't mince words. He didn't try to hide. And he says, that's why I believe, Your Honor, this is not an ethics issue. This at most is a discovery violation dealing with that. I thought that was a brilliant way to phrase it because, again, yes, the prosecution, they apparently inverted their videos. They lost the car video. They just turned over 3,000 pages of documents, and we're talking about one page.
Mm-hmm. And it's not a particularly consequential page either. So it wouldn't have given the state much. The state needed the essentially the basic outline that the ARCA expert, and what's his name, Dr. Wolf, had turned over to had given to Alan Jackson. That would have been it wouldn't have done very much. I thought Alessi was pretty phenomenal yesterday. You know, again, I don't know how he is in front of a jury, but I want everybody to understand that it's hard enough when you're a lawyer to carry water for your client, but then to carry water for your client and the lawyer that swore them all in, which is you know, David Yannetti. Then on top of that, to carry water for Alan Jackson, and then on top of that, to carry water for Lisa Little, and then on top of that, to be able to identify throughout every point, he was being literal. All of his arguments ended up being literal. When I mean literal, I mean, so he said that we didn't pay, and we didn't offer to pay, and that came out of the blue. And they didn't know that this was something that, you know, hadn't been disclosed or hadn't been turned over. And didn't know that he had said something that was. When to go through that much detail and for all of that to line up is really pretty incredible. Very, very, very literal. The one thing that I thought that he ended up doing, which I know I just picked up on it, that I thought he got nervous about, was after the judge again went, you know, to like in Congress where they went to go ask, you know, the CEOs of all the cigarette companies, you know what I mean? Exactly.
That whole picture, all five of them raising their hand in front of Congress, right?
Exactly. And then turn to Mr. Yannetti. You don't have to, and then Mr. Jackson, and then Ms. Little. And then you saw Alessi try to stand up and say something. And my guess is that he he wanted to maybe fine tune. I don't know, because the judge didn't let him talk at that point. He wanted to fine tune something that was presented at that point. I don't know what it was. And she said, no, I've already heard from you. I'm going to hear from, from the state. So the Commonwealth. I thought he did a pretty terrific job of carrying water for, all of that. I mean, that was a lot.
Well, we have that moment. Instead of doing the calendar first, why don't we do, since you've mentioned it, that moment where the judge questions, and I asked our wonderful moderators, Missy and Dizzy, to clip this, to find it and clip this from yesterday, because somehow I knew you would go there. All right, why don't we see if we can play that, and then we'll go back to the calendar.
You said I could ask questions of other counsel. So while memories are fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Kenney. Yes, ma'am. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely accurate.
Okay. Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making a comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I did as well.
I did long before I looked at the transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small
invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about.
See, Alessi, to stand up.
Requests
right.
Concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the...
Nope.
Okay.
Hold on. Ms. Little, it's just thrown on you that you're responsible for all discovery. But the same question, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay.
That's the what you had been referring to, Neil. Comments?
Yes, the three wise men. Yeah.
Three wise.
I don't view this as a candor issue. I just don't. I just fear that the judge is going to take it as a candor issue.
Yeah.
I just don't view it as that.
Yeah. And well, let's go through the timeline as we talk about this. I think this is important. Okay. If we can put this up and everyone will try to enlarge it, even if there we go. I don't know. Can we enlarge that even a little bigger? Is it go one more? Let's see. No, that's it. That may be it. Okay. That's about it. Okay. Unless we go to another state and do a different show. All right. So I can read it because I have a printout of it here. All right. 2/12/24, the ARCA report was completed. Remember, they're waiting for the federal government. Approximately on 2/21/24, it was received by all parties. 3/20/24, AJ, he communicates with ARCA, but it's on the issue of, I'm going to send you a retainer, the terms we can discuss later. And I think my opinion would be that's because if he's going to talk to them, then he wants to get an attorney-client privilege.
You need to.
You need to at that point, or else just call your malpractice insurance policy, even if they had the report in there. There we go.
And Linda, tell it you need to explain. You need to, because at that point, ARCA is only, the conversations are not work product unless there's. They need to be work product protected and privileged.
Right. Yeah, because you're representing a client, so you have to protect them. And so I don't know whether there was any. We haven't seen that proposed retainer anyhow, so we can't talk about whether there was any fees in there discussed. On 3/22/24, that Paul's email that ARCA's contracted to the feds, so you can't have a retainer agreement because they're under contract to the feds. So tough cookies. And that's why, by the way, you can't speak to them if you're the attorney for the defense, because then they're going to know, the feds, and they can talk to the other side about what is in your mind about what you're going to ask, right?
Yes.
So, right. So it's Paul's. 6/10/24, defense, let's see. Okay, informs Kenney that there's been no trial prep of these witnesses, okay, which is true. 7/24, defense receives, that's 7/24. This is after the trial, right? Trial's ended. The state's already announced, the Commonwealth announced they're going to retry. Defense receives an ARCA invoice. They said yesterday, out of the blue, because I guess the assumption was the government, my assumption, I'm drawing an inference, is the government, they assume, was paying for the testimony, since the government still had a contract, so they assumed the government was paying. So yesterday was represented that then they called the defense, Alan Jackson, the defense calls the feds, and the U.S. attorney, who no one ever spoke to but Alan Jackson, says, "What the heck is this? Do we pay this? What's this bill?" And he said, "Yeah, you can pay it." So the trial's over. What are you going to do? Go back and tell everybody that you got a bill from them if you hadn't agreed to a bill, if they had no retainer signed from them? No, the answer is no. But with a new trial looming, my feeling would be that's when they paid it, right?
And this is about, there's two different issues. Issue one is, what did you do that reflects on your conduct in the first trial, which the judge has said, we're not litigating what happened in the first trial. And the second issue is, what are you doing in the context to notify the other side in preparation for trial two? Well, they're going to call the ARCA witnesses in trial two.
Right. And I missed something here in my loop. On 6/18, there was the voir dire of ARCA. 6/23/24 is when the email of the question, the outline, the notes, or whatever you want to call it, happened, that they were turned over. And then 6/24 is when the first ARCA witness testified at trial. Okay. So you have 6/23, there's an email of notes, which apparently outline Jackson didn't use. And he said to the court, I think Leslie said, look around, you can compare the outline that they sent versus what Alan Jackson asked. What Alan Jackson asked reflects the report. It has nothing to do with what this outline was. I mean, we haven't seen the outline, so we don't know. I mean, I don't know. And then you had the invoice being generated. Then on 7/31, the ARCA contract expired with the feds. Defense contacts ARCA, confirms that the contract is expired. Then on 2/6/25, defense contacts ARCA. Now this is months later. This is like after trial. So ARCA contracts expires in July. 2/6/25. Okay, so now we're in the new year. Defense contacts ARCA, confirms their contract with the feds is expired. Then on 2/13/25, defense turns over all of the ARCA, the stuff that they hadn't turned over before. And then 2/18/25, the Commonwealth then accuses defense of discovery violation. So basically, once the contract with the feds expired and they confirmed it, they turned over the discovery, including the fact that there was an invoice and they paid them on 7/25. And that's when the Commonwealth says you have a discovery violation and you're an ethical violation. Well, actually, the court takes it to be an ethical violation.
Right.
Right.
Right. There's a discovery, and then they're turning it into, they're conflating a discovery issue with an issue of whether the lawyers were candid the court and the jury.
So we do have a couple questions here. SGR asks, if she does remove Alan Jackson, can Karen appeal? And Neil, when you answer that, answer it with this also in mind. The prosecution's now going to argue in the first trial when they go after the ARCA experts, well, you didn't tell us that you were going to send the bill or being paid, and weren't you being paid? Didn't you have communications? So does ARCA, this is kind of like a 1A and a B. Does ARCA now become sullied by this? And number two, do you think that any attorney should remove themselves so that they're not the subject of the attack on behalf of Karen Read?
So to answer A, I think that ARCA could end up being sullied a bit. I think that they will end up, there'll be a little dirt on them because the defense is going to, or the prosecution is going to attempt to spin and cross-examine and say that they were working in conjunction with the defense, and that they submitted an outline, they were prepped, they were expecting to get paid, they were anticipating getting paid, they wanted to get paid, they did ultimately get paid, for services, whether it's for testimony or for prep or for time or travel. I think that they'll get some of that. I don't know how effective in the end that's going to be, but look, no expert takes a stand except for your husband, takes a stand and ends up, testifying without blemish. But look, the fact of the matter is that was a compliment to
I just will crow again, and Michael did was awarded last year in front of all these 1,000 people.
Yes.
The Innocence Project a Merit Justice Award for his 30-some years of pro bono work.
Well earned.
In the field, including he did a report for the original attorneys early on, before it was a thing, in the Glossip case, saying that. Saying something, saying that I realized I haven't seen the report, so but obviously.
I think the second is that your second question was, should an attorney...
First was, can she appeal? Yeah. Can she appeal?
So yes, she could appeal if they attempt to remove Alan Jackson. It's a little more challenging when you're with a pro hac vice, because if the judge finds that Alan Jackson did something improper, finds that he violated the rules of ethics, as opposed to a discovery violation, but violated the rules of ethics in Massachusetts, and removes his pro hac vice status, she'd have to appeal to the appellate court and have to make an argument that she was denied her Sixth Amendment right to counsel. There are some cases where the courts do balance your right to counsel of your choice with whether someone is entitled to have an out-of-state pro hac vice a lawyer. I think in the end that Karen would win that appeal. I'm particularly on the record that I saw, I think that she would win that appeal. I think there are other ways to deal with the issue without the ultimate sanction. And I think the prejudice to Karen Read, if they remove Alan, is tremendous. You're talking about someone that has been involved in nearly every facet of her trial and in preparation for her second trial. This is a yeoman's effort. Few lawyers know what it's like to be involved in a months and months long trial, let alone the defense of a client that takes over a year or 2 years.
Yeah, I've been involved in a number of them. You live, breathe, and eat it.
How could you replace you? If just imagine from your trial with Specter, had you been removed from the case somehow, who could possibly have picked up every nuance of everything that you went through for those years?
Right. You know everything. You know everything about the case. You can maybe be removed, as I was, not removed because I had pneumonia and almost died for about 3 weeks, that I had to leave the courtroom because I trusted the team that would prepped very well for those 3 weeks, one of which was a visit to the scene.
I think all of this attempt at cloak and dagger, which the courts do for reasons, is just silly. The judge should just just say what the circumstances are. Here's the deal. They were hired to do a federal investigation. They were involved in the federal investigation. They were nobody's witness in the beginning. The defense was interested in speaking with them. They made their information available to both. Experts expect to get paid. Then there was a pause. Then after they testified. Then after the pause, they end up getting paid. Again, both sides are able to speak to the ARCA experts. That's the history. There's nothing magical about it.
Right. Shigel asked, do you think Bev will make her decision, Judge Kenney, that is her decision tomorrow? I think it's possible because the attorneys have to be in federal court. And she said for them to come back on Tuesday. And was it Tuesday and Wednesday next week or Monday and Tuesday next week? Yeah. So I think that is possible. That comment that they should be back in court kind of indicates to me that she's not going to pull this, that maybe she's talked to people, that there's other issues here that she may be concerned about, because she wants to try this case April 1st. Can you imagine pulling lead counsel off April 1st? And that's why, to me, Brennan said about Yannetti, I'm not talking about him. He's the most honorable, wonderful, terrific attorney. All these other people from all over the states who have pro hoc, what do they need to do here? Mr. Yannetti can handle this case. I think that's why he said that.
Don't you? As you know, Linda, whenever you're the defense lawyer in the case and your adversaries start blowing you up like a balloon to the jury or to the judge, they don't need 7 lawyers. They have Miss Kenney Baden. She's more than capable. She's a brilliant star. She can handle the whole thing. And you're sitting there like, what the hell do you know?
Right. I know.
You've got 40 cops and 15 different police departments running around doing your shit.
Right.
I'm sleeping 2 hours a night, waking up in a cold sweat, realizing that I put the wrong date on my proof of service.
Yeah, and I had to have the attorney get a subpoena out and make sure they get it. They have, and you always hear, the state, and look at all those. You heard it, but you heard it in the ASAP Rocky case. But I did say something I think you'll find funny. I said, and we're going to get to this. Can you stay more than 7 o'clock? Because we have a lot of people joining. Because we have a lot to go and a lot more people joining. Yes. I said, you know what, Mr. Brennan, and he's a defense attorney. He represents Whitey Bulger. He's not. He knows what he's doing here and why he's doing it. Okay. I said, maybe you don't really want to get rid of Alan Jackson, because then maybe you're going to end up with Jose Baez and Joe Tacopina, right?
You could get. Trust me,
someone like that.
As you know, exactly. You know that if Alan Jackson is somehow removed from the case, somebody is going to parachute in.
Right.
Somebody else who's of the same stature and is going to say, to hell with it, I will jump in and jump in. Now, are they going to have Alan's knowledge? Are they going to have his organization, his cross-examination skills, his stopping and starting? But someone's going to jump in. And remember, as we always, a plastic surgeon that I know once said to a client who came in for a consultation and said, well, yes, you look like this now, and I know that you want change, but remember, change isn't always going to help you. Change could actually be worse.
Right, exactly. Lauderdale Amber, how would ARCA employees know what the feds weren't going to bill? They couldn't know what the feds were going to pay them. I guess who the heck knows what there was going on between the feds and ARCA at that point once the contract ended. Maybe they were kind of like, I do this for the feds, and all of a sudden I'm involved in a state case, and they'd have to go. Who the heck knows? We don't know.
Let me answer that in a way, Linda. Let's imagine that the cross-examination that this information was the sort of information that in the middle of this complex trial with all these different moving parts that Alan Jackson and David Yannetti and Ms. Little just disclosed and said, here's the outline they sent us. There has been talk of payment, but we don't know what it is. We do have a retainer because we have to have work product privilege with them. We don't fully know what they're going to say. we haven't traditionally prepped this witness, but the witness did give us an outline. And he did ask us this question, whether or not we wanted to go into this subject matter or not, which Alan Jackson ultimately did go into with the witness on the witness stand. What was to be gained by what does anybody who's advocating with Hank Brennan, what did the defense gain here?
Nothing. It looks like they've gained a lot of problems.
What did they? I mean, this isn't like a hiding the ball thing. I mean,
yeah.
What did they gain? What was purportedly hidden? That there was a retainer agreement. There was a pause.
An unsigned retainer agreement.
Right. I mean, that's to establish attorney. What else? That there was a bill that came after the trial. You can't disclose that in the middle of the trial. That there was that the experts sent an outline that of voir dire before that Alan Jackson didn't end up using. I mean,
and that would be work product in the normal case.
What was there to? They didn't gain anything.
Well, let me ask you this. That brings up an interesting issue, because if they were Alan Jackson, retained by Alan Jackson, any outline that they would have sent, I don't think would have been discoverable. I think that's work product as to what you're going to ask me when I get put on the stand.
I agree.
So the fact that they now sent it as part of discovery indicates to me they weren't then viewing it as work product because they weren't retained by them. I mean, that's
Correct.
a distinction no one argued.
And I think there's two different. We're talking about. Remember, this is a complex issue, not too complex to understand. But let's separate the duty of candor, which is what we lawyers have, the duty to disclose things to the court that are true or untrue.
Right, as an officer of the court.
As an officer of the court, and the discovery issue. The question is, this is being conflated now by the state. The state is claiming that Alan Jackson and the ARCA experts hid the ball. Now, in the second trial, where there's no more federal pause, they've been released to do whatever. It's all being turned over to the prosecutors because this is what the judge has ordered under, what is it, Rule 14 or whatever the disclosure obligations are. At the time, it's work product. There's nothing to turn over.
Right. That's exactly a distinction that I don't think was made yesterday.
So
I just thought about it as I'm asking you the question.
Yeah, I mean, the state had the state had their opinions.
Right. That was it. The state never called anybody. Like, hello, pick up the phone. I said, of all things, the state, just pick up the phone.
We're in the middle of a battle right now with the prosecutor's office in a part of the state, and some experts where we want them to disclose not just the final opinion, but we want them to disclose the communications between. Now, we would get the communications between the police departments and the experts,
right?
But we want the communications between the experts and the prosecutors, and the prosecutors are telling us
work product.
Right.
As a matter of fact, I took that issue up on appeal like 20 years ago to a federal court. I argue that when you're a prosecutor, there should be no work product because you're being paid by the public and you have the certain duty to the public of which, my client is a member of, and the district court in New Jersey, federal district court, held it was work product.
So we're in a battle over that because we're in the midst of a Daubert issue, and
thank you for saying Daubert correctly. I had this fight with Michael Bryant all the time.
What does he say?
Daubert.
No, it's not Daubert.
It's not. I said just listen to the person whose case it was say his name. He kind of knows what he's called. It's Daubert.
So I too, I'm hopeful that she doesn't. Look, I enjoyed watching Alan Jackson in this case. I thought he did a really terrific job. I thought I thought he was precise, and I thought that he took it to the state's experts where they could, and the state's witnesses. I'm always interested to know how he got involved in the case. Interesting connection between he and I forget the woman's name, who was the canine bite expert, and John Lewin.
We're gonna get there tonight too.
But you know, yeah, I think the state has to be careful because there's no way that David Yannetti is going to be trying this case. I know what I would do if I were Yannetti. As much of an ego as I have, if the judge removed Jackson, I would just stand up and say, Judge, you can do it. You can do whatever you're going to do, but there is absolutely no way that you're going to pull me into a trial of this magnitude where you just remove my co-counsel and lead counsel from the case. It's not possible for me. I'm not going to put Ms. Reed's life on the line and attempt to try the whole case myself in a month and a half. It's not going to happen.
Yeah, an interesting, this brings up an interesting war story, and I wish Bob Bianchi were here because it happened in New Jersey, that there was a public defender who was ordered to represent and go to a trial in a case that she wasn't prepared for, all right, because they pulled somebody or whatever. I forget the complete circumstances. And the judge said they had order. You know what she did? Take a guess.
Please tell me she did what I said.
She resigned her law license so the judge couldn't push her.
Wow. Ballsy.
That's how
and committed. Yeah.
And committed.
Yeah.
Resigned her gave up her law license so that no one could say, you have to go to trial, all right? Because she thought it would be a disservice to the client. Now that is something.
Yeah, that's a warrior. Yeah,
that's a warrior, right?
Yeah.
That's a warrior.
Yeah.
Resign the law license, all right? And it was a public defender also. I mean, just wasn't going to play that game. You know, you want to try to push me? You want to try to appeal? You want to do this? Nope. And of course,
I think this whole case highlights something very interesting that is so lost in our legal system. I'm so frustrated. I'm regularly frustrated by the the lower standard that is held to the party and the lawyers on behalf of the party that represent the public, which is the state's attorneys. Look, Hank Brennan got up there, I mean, and he clearly misrepresented what was, you know, the exchange, where he got that information from. He clearly misrepresented that. I just want you to picture a defense lawyer doing that.
Oh my God, that's it. Our license would be pulled. Okay, that's it. We always, our license, and then what do they say? The first thing they say is this is unethical when they argue again. Unethical. Absolutely, our license would be pulled. No doubt about it. And that's why people don't understand. And that's why, you know, we had just been talking with Michael Bryan and I we thought that maybe there was a tide turning given the YSL case and Weinstein, and given Joe Tacopino now in the ASAP Rocky case and some other cases but what do? No, and that goes and pushes the narrative, because I've been a prosecutor also, but it pushes the narrative that all you defense attorneys, you're slime, you're miserable, you're unethical, you know, and it's wrong. It's simply wrong. So that's one of the reasons why Michael and I actually.
You think about, so I've been a prosecutor, AJ was a prosecutor, you were a prosecutor. Right. Think about what happens when the state, think about, and I do this in voir dire, I ask jurors about impressions and preconceived notions. And I talk to them about TV shows. Who's watched TV shows? Right. And you guys have all watched Suits. I watch Suits. What do you, Law and Order. Okay, with the great noise, right? All right, you know what I mean? And how do they portray Harry Waterstone, if there's Sam Waterstone and the prosecutors in Law and Order?
Oh, wonderful.
Virtuous,
right.
Dogged,
right.
Underpaid, tireless,
right.
committed to justice. And then the jurors, I said, okay, you know what's coming, right? How do they portray the defense lawyers? And the jurors all look at me and I go, come on, you know. And they all, how do they portray in Suits and the scummy and underhanded? And, you know, I mean, that's.
Right. And you always have shows where, what is it? The prosecutor or the defense lawyer is representing somebody who's they thought was innocent. And it turns out he learns or she learns afterwards they're guilty. And what do? Oh, my conscience is so bad. I got to turn around and I got to become a prosecutor to right that injustice of being a defense lawyer. That there's never a prosecutor who's wrongfully convicting somebody who then has a TV show and becomes a defense lawyer, generally, except you have Matlock back.
No, I mean, I just, you know, look, if you stand up in open court and say da-da-da-da-da, and then breathless and everybody freaks out and the judge begins to want to issue sanctions and the lawyers are left trying to figure out, what are you talking about? and the public narrative takes off. I know that maybe isn't the focus, but that was, Hank Brennan was definitely playing to the media a bit when he would did the shh, that would be nice to know. And, you know, he did all of that drama and then comes back later and go, oh, by the way,
I misspoke.
by the way, forget that. Forget that.
Forget what I said.
Forget.
Yeah.
I juxtaposed D and E. I'm sorry. Forget that.
Yeah.
Forget that.
So, Walnut Amber asked, would they take that to the Supreme Court? That it's the Supreme Court of Massachusetts. It's actually called something different, but I would think they would. I think with the law license, you can go directly there, or you certainly would make an application, as we did on an issue in Hernandez, for them to take that issue directly up, and they probably would. I would imagine they would do that. And then there's something that happened today. There was a filing supposedly under seal of a motion for prosecutorial misconduct. I don't know if I saw that or if that's been confirmed. Can you all tell me? Because I was, after I worked, I came back and I was busy getting ready for the show, reading all of these wonderful assets that Missy and Dizzy had pulled out that you're now seeing.
I want to know what EC. I want to know what EC stands for.
Wouldn't you like to know? Hey, AC, you can blurt it out on the show. You can come on the show and blurt it out. You know, like ASAP Rocky did about Og. Right. Whoa! Wait. Oh, did you hear that?
No.
Oh, okay. All right. Will the defense be able to argue the impounded motion dismissed prior to the judge's decision on this?
Probably not. But so what the defense filed today was a motion to dismiss for outrageous government conduct, which we haven't read it because it's impounded, and I think that the defense has to work on. There's something they have to do to it to make it available to the public. Maybe remove. Maybe there could be some personal biographical, some personal information. I don't know that they have to redact or something. Interestingly, is that the timing of that motion is obviously whether they planned on filing it all along or just planned on filing it, or they worked on it all night to file it today. Is pretty interesting. I am curious if part of that relates to Hank Brennan's, part of his presentation where he mistook and misstated, charitably misstated.
Right.
What?
Right.
This
whole thing. I mean, it's really. When you look at it, I mean, first of all, if you get something, you can't be talking about the bill because they've now disclosed that. So all you're talking about really is the outline, the unsigned retainer agreement, and an email about Paul's. That's it. You're really talking about the outline because it's an unsigned retainer agreement, so it's not, it's never signed. It's an email about the federal government's pausing. And then really what you're talking about is one document, the outline, the note, the alleged outline where he's, asked me these questions or something like that.
And all of this with the Hank Brennan's, they paraded themselves around as though they didn't have any relationship and we're allowed, they have no relationship. I mean, I hate to say it, man, like, welcome to the club, Hank. How the hell do you think that we defense lawyers deal with shit all the time when we get some expert out of nowhere who says, I'm just getting paid to drive to and from here because I want to tell the state. I mean, this was like the tables were turned in so many ways in this case because people were coming out of the blue wanting to clarify things that the state was arguing in trial one.
Right.
And that happens to us all the time.
All the time.
We're in the middle all the time. Oh, this information just came to us. We didn't know it. But,
we didn't know it. And the judge said, okay, we'll just give him over. Or you're in the middle of trial, you get it. And then, you can have a few hours to read the 2,000 pages.
Then you get the backhanded compliment, the gratuitous balloon blowing up, where the prosecutor will say, and you're like, Judge, I had no idea. How am I supposed to deal with this in the middle of the trial? And
they tell you how great you are.
Oh, Your Honor, this is Linda Kenney Baden. She's one of the foremost trial lawyers in the world. She's at Harvard. Of course, she's got a firm of who knows how many. She's got lawyers that will step up. Of course, someone of her skill and ability could handle this in a heartbeat. What are we talking about? She's no rookie. Ms. Bond, how much time do you need to look at this material?
Your Honor,
do you need the lunch hour?
Your Honor, I may want to have an expert review with me. I had to go through it. I want to talk to the people that are mentioned
You
here.
can have the lunch
Oh
hour.
yeah, well, you know what? I'll tell you what. We won't deal with it till tomorrow. You'll have the overnight.
Right.
You can play overnight. Right.
Oh, that's great, Judge. Because you know what? I was going to take tonight off in the middle of this trial. I was gonna watch my shows. I was gonna Netflix and chill. Good. Cool.
Yeah, we all have that. It happens all the time. All the time. People don't realize it. So
Yes.
I assume that when we do get a decision, I want you to come back on the show because I want to like move on to a different topic right now, but a related one. Actually, Missy, I told you we weren't going to do Glossip today, but I really would like to talk about the Glossip case. You know,
do your viewers want to talk about Glossip? Do they want to hear about the Glossip, not gossip?
Yeah, let's gossip about Glossip. Let me tell you, this is a guy, this is a Supreme Court decision, 5-3, by the way, where a death penalty conviction in Oklahoma has been overturned after years of fine. Our Supreme Court, who would have thunk? Okay, who would have thunk? Okay, and it's a real issue here. But he came within this close to being executed with drugs that the Oklahoma was getting from another state. And trying to get and unused and use because they couldn't do it. And his attorney's been fighting for him. And I told you, my husband issued some report. I don't know what it is. I haven't seen it years ago, right? Because I remember the whole thing, what you're saying, gossip and glossip. And I think it had something to do with the, Innocence Project, whatever. Innocence Project, whatever. I know it. So, but tell us why it's important in the context of Karen Reed. Okay?
So important. And if you would have thought
we don't, Missy, we don't even need to play the we don't need to play the we have an MP4. We have a news article. But Neil's going to set it up.
I'm going to set it up. This is such an important issue. What is the prosecutor's duty? Right? And I'm not trying to get academic about this, but what's the prosecutor's duty? The prosecutor's duty represents all of us. To someone who represents the state, represents every single person in that courtroom, including the defendant. It's their obligation. If a witness gets on the witness stand and says something that's false, it's their obligation and their duty to not just hope that that the jury will ignore it, but they have to stand up and actually affirmatively correct it. Very few do that.
Few. And the problem you have is, and there's another war story from New Jersey. When I was a prosecutor, I had an investigator who was testifying on the stand in another matter, and I went down to watch because I was a trial team leader, right? And had all the sexual crimes unit, sexual assault unit and all. And I heard that he had really misstated some testimony, especially related to his qualifications. I walked upstairs and I didn't have any qualms about it because I knew it wouldn't put me in good stead with everybody I'm working with, including investigators, and reported him to the prosecutor of the county. Reported him, I said, this has got to be corrected. This is wrong.
So, I mean, your viewers will know way more. Our viewers, subscribers, will be able to identify, and they should tell us how many different times during the Karen Reed trial did they see the prosecutor or a witness take the witness stand and say something that wasn't true? And did they ever see any of the prosecutors, whether it was Lally or anybody else, ever stand up and just say, "Excuse me, I have a duty to correct what you just said"? That doesn't happen. What happened in Glossip was that they have a witness. The witness, Glossip was convicted, I think it was twice, of murder. And in the end, the state called this guy whose name is Sneed. He wasn't a very strong witness. He was the guy. He was the witness that the state accused. They said that the defendant, whose name is Glossip, just to keep it all clear, the state's argument was that Glossip used Sneed, that Sneed was not typically violent, and that Glossip had set Sneed, like he had wound him up and then sent him out there to go assist in a murder. And then they called Sneed to testify against Glossip. Now, Sneed was on, this is important, Sneed was on lithium. He had been diagnosed as bipolar. He told the prosecutors that he'd been given Sudafed. And he told the prosecutors that he had never seen a psychiatrist when he was in jail. And the state had a big box of material showing that he had been given lithium, that he'd met with a psychiatrist, and that he'd been diagnosed with bipolar. And when Sneed, the only state's witness, and he was a witness that the Supreme Court said, they described him as nobody's idea of a strong witness. The entire case rested on this guy. The entire case rested on this guy.
Right.
And
who may be the killer, right?
Yes.
That's the second.
And didn't actually, he was turning back and saying, hey, Glossip was responsible. And the state never corrected it. They just let him lie. This is how bad the lie was. Okay. So now the Supreme Court in a 5-3 opinion has said that it is the state's duty, a prosecutor's duty, to stand up in the middle of a trial and to correct a lie by one of its witnesses. And that's a huge, this is a case that should be cited left and right by defense lawyers all the time. You should have this in your trial, your trial notebook.
Right.
When they don't correct it, call them out and say, Judge, he's got a duty to correct that. Not just chalk it up to a contradiction. We saw this in Relly. We saw this in ASAP.
Right. We're going to talk about that with Lewin, because this has also.
Stand up and say, Your Honor, that witness is not being truthful.
Right.
Now, what prosecutor wants to do that? Because you'll lose the case as soon as you do that.
They'll put up witnesses, as we saw in Relly, knowing that there's a tape out there that the guy says, I need to only have a lawyer to go through it again. I need only to have a lawyer because I need the bag. But that's the next case we're going to talk about.
I'm just going to the Supreme Court actually in a 5-3 opinion, which came out of, I want to tell you how important this is. This came out of Oklahoma.
Right.
And the Oklahoma Attorney General agreed with the error. The Oklahoma Attorney General said the guy is entitled to a new trial. The Oklahoma Court of Appeals said, no, he's not. And when it got to the federal court level, the Oklahoma, the Attorney General was agreeing with the defense. And so, what the court, they had to appoint somebody to argue on behalf of the state of Oklahoma.
Right.
And this is a great
that's
line.
Why it's a great
favorite line. It's my favorite line from a case. His willingness to lie about it to the jury. And he goes, a lie is a lie, no matter what its subject. A lie is a lie, no matter what its subject.
A lie is a lie, no matter what its subject. And this is a 5-3 decision. This wasn't one of those closer. This was an amazing.
This was what a fantastic, and I don't know Glossip. I don't know his culpability. Right. I don't know Sneed. I don't know his culpability. But the legal system is supposed to not have.
But I think was it Glossip saying that Sneed may be responsible?
Yeah. Right. But Glossip has said he didn't do it.
He didn't do it. He didn't do it. Right. He said he didn't do it. No.
Sneed's credibility was the whole case.
Yeah.
And you know what? I mean,
it's a great opinion. It applies to Karen Reed. It applies to ASAP Rocky. But before we get to the reason why I picked the Syed case to talk about in relation to both Karen Reed and ASAP Rocky is, let's just put up the PDF, Missy. We don't need the report right now, the breaking news report. Adnan Syed, I'm going to pronounce the name, Adnan Syed. Okay, all right. This is what happens when you're. You know what? I've been so interested in talking to you. I haven't had my Dunkin' yet today. And I'm not looking for a sponsorship. It's just true. All right. Although if you like this channel, please hit that like button, share, subscribe, and notify, please, and hit that bell. All right. But remember, he was the subject of the Serial series that started the whole podcasting. It engendered this. I read today there's 1 billion people that listen to podcasts on YouTube now. This is the Serial that started this, and reinvestigation, and they went up on appeals and rejections and appeals, and finally a court actually because Marilyn Mosby, who was the Baltimore prosecutor, said she agreed that there were problems in the trial He was let out on bail pending, he was let out on bail, right?
Right.
His case was going to be
Right.
dismissed. The victim's brother eventually said, and this was during the pandemic, during COVID, look, I wanted to be there. You gave me only a night's notice, and I could only appear by Zoom, and that is less than I'm guaranteed under the Maryland Constitution, right? So I have a right. I had all these rights. So the court reverses. The conviction reversal, but puts him out on bail at that time, saying, okay, I think this is a bullshit thing, but they did it, all right? And from here, it even gets, I think, worse. Today, or yes, there was a hearing that as to whether or not he could be resentenced as a juvenile offender under a new law that went into existence, that if you're convicted when you're 17 years old or 18 or under 18, you can be resentenced after serving a certain amount of time in prison. And so he's applied for resentencing. But why is that so important that he's applied for resentencing on the judge? Because the new state's attorney, prosecutors come in, who says, I withdraw our objection, not our objection, I withdraw our support of his motion to have his conviction reversed because I think he's guilty, or whatever it is. I want to review. I thought I saw some report that says that they said he was guilty, or he thinks that he could be guilty, or whatever. I don't think there's been that quite a review. So this whole hearing today was important as to whether or not he could be resentenced. He'd still have the conviction, but he'd be resentenced as a juvenile offender for time served, and the conviction would remain on his record as opposed to being exonerated as an innocent person. So that's what happened today. So when you say that the Oklahoma Attorney General was for the position of Glossip being his conviction being reversed, that's very important, because in Syed, there's where we are now. By the prosecutor, political prosecution, political whims of a prosecutor coming in, and maybe it's not whims, but the politics taking hold here. We have all these years of 12 years of litigation that may go asunder, and he may go back to prison.
In Glossip, they found 8 boxes of material that had not been disclosed or turned over. 8 boxes. In the Syed case, which is a extremely controversial case about the ins and outs of the Syed case.
Right.
It's frustrating that you can have a prosecutor, you could have not just a change in party or policy, but you can have such a dramatic change in approach to a particular case. Look, I feel terrible for the family of the deceased.
I do too.
I do. Right, I feel horrible.
She was brutally murdered. Right.
But I'm also capable at the same time, because I stand next to people and defend them in court and meet with my clients' families. Can you just imagine, without judgment, just put aside the judgment of what you think of Syed or the case, just having to sit down and explain, hey, I know, listen, here's where this is going to go from here. So he's been out. Now we were close to getting, we're close to getting him out, and close to the conviction being set aside and potentially having a new trial, or them deciding that. So that's over. Now our best chance is maybe to argue that he should be sentenced as a juvenile, or resentenced as a juvenile, or treated as a juvenile under what is kind of like a juvenile life without parole type, like a Miller type proceeding. I mean, that's a hard conversation to have with somebody. That's a tough, that's a painful conversation.
And the judge has to make a decision. She said she's not going to let it go long, but she may revoke his bail.
Yes. And
put him back in prison where he hasn't been. He's been working for the Exoneration Project in Georgetown Law School all these years now. And I don't mean to say political whim. That was probably it's just that
but I know what you meant. It just
politics changed of the people in
you don't
power.
Mean whim, but as the wind,
the Bob Dylan. Here we go.
The winds blow.
Right. The wind blows.
As the winds blow, someone's lives change.
Right. Right. And for everybody involved. And it's tough for everyone involved because the victims' families always feel, or for the most part, I find that even when there's a wrongful conviction reversal, that the person is guilty because they've been fed this for years. They believe it for years, right? And you seldom find a victim will say, as we've seen a few, that'll maybe appear on 60 Minutes with somebody and sit down next to somebody. I'm sorry, that I was wrong. But it's imagine being in prison. And we know we have the Innocence Project for all those years and you weren't guilty, but the families still think you are, even though they're out after you've served 40 years and evidence came by that showed that you were innocent. It's a system. The system is under fire. It may be the best system, but it's got some serious problems, man.
That's stressful stuff. I just can't even imagine so someone gets out of prison, they're out. And again, I'm not trying to play the part of bleeding heart here. I'm just talking about people. The victim's family is going to be devastated. They're devastated that the person gets out.
Right.
And then the person gets out and they're out. And then they have to at some point go from, they've been out and now they may have to go back in. They weren't convicted. Now they are convicted. They got a bond. Now they, it's
a terrible situation.
It is and I don't know the way around it. I know that when prosecutors change, I've seen it. We were gonna. Someone has a policy where they are no juveniles are going to be prosecuted as capital offenders, and then the tides change a bit, and then you have someone that comes in and says, anybody who's accused of murder, regardless of age, whether they're 13 or 18, is going to be treated as a capital offender. It's again just the winds blow. We keep saying that. And it is a change, and it's just a change that is very difficult to explain to people.
Well, on both sides. On both sides.
On both sides. The legal system is meant to. We want it to have some consistency and some repeatability and some predictability, and unfortunately, it doesn't.
And justice.
And it doesn't really, and a lot of times, doesn't have any of those three things. And as you know, justice is often identified in the eye of the person who wants a particular result. The person wants justice who's the defendant, and the person wants justice who's the victim, and they don't see justice the same way.
By the way, Lewis Harris, thank you. Dr. Baden helped put the very corrupt can comment where he should be. Well, he got that as a civil case. My husband got that as a civil case. That's talking about the Sandra Birchmore case. And the only how I know about it is we were up at the cabin, which is very small. One day, I'm downstairs in my office, and his phone. So I hear his phone upstairs because it's a cabin. Ringing off the hook. And apparently, all this media were calling, and and I said, "Why the media called?" He said, "Well, I really can't talk about it." So, that's my relationship with.
Can you guys? I just want you to imagine for people that are. I love Linda so much, and I have such a dear affection for you, and obviously for Michael. But the rest of us are sitting down having dinner conversations about, like, did you get air in the tire? And you know what I mean? Like,
then they come up to, if they ever came up to our apartment, you got the poison book, and
you guys are having dinner conversations. Like, God, I can't even imagine you guys. A crossword puzzle you want to do with Linda? Heck no, that's too easy. Let's talk about physics and.
I know. I've seen some of your cross-examinations. They're pretty great.
Some of them are
Kay Schmidt gifted 5 Justice Serve TV memberships. Thank you very much, Kay. All right. So, Linda, have you ever been before Judge Beverly Cannoni? No, I have not, although she does teach. I saw this year she was part of the faculty of the Harvard Trial Advocacy Workshop, where I do a lecture. I'm a part of the faculty in the first week. And then there's 3 weeks. The third week is usually the judges, and us, like the first week people, we never get to mingle with like the third week people with the judges. So, but I did see.
How would you have handled yesterday Linda.
Well, I come from a defense attorney viewpoint, and first of all, I would have because of the extreme prejudice it could have created to the client, I would have then said, we will discuss this back in chambers. It'll be under seal, what we're going to discuss, and until after the trial. That's how I first would have handled if I'm a judge. Secondly, after we were listened to that, I would have said, this is ridiculous. This is ridiculous. You got the discovery now. No harm, no foul. You want to argue in the future, are you really seeking to pull his pro hoc vice, Mr.? I would have asked him point blankly. Are you
right
seeking? He never got asked that question. All right.
No.
Is that what you're seeking, sir? And because we know from being defense attorneys that this is nothing.
Yes, on the Richter scale, it's a 1 or a 2. It is not a candor issue. It really isn't.
It's not. It's absolutely not. I mean,
would you have argued the thing the same way as Alessi? Had you been arguing on behalf of the defense yesterday?
I thought he did a brilliant job. Yes, I would have, except that when I talked to you, and this is why talking to people is important. He probably didn't get time to talk to anybody. Once you realize that they handed it over, so they viewed it as discovery. But if he had the retainer agreement with them, then that's would have been protected under the retainer agreement to begin with. And I think I would have made that I would have said that, made that distinction. There's no reason for him to hand it over now, because now he did pay them, right? So if anything, the privilege now would really apply. So I think that's something that no one really brought up. And you elucidated it as I.
Why do you think Alessi got up again? Why do you think he got up after?
Because I don't think he said that they would talk to you generally about, would you say everything I said was accurate? I think he said you can talk to them about the phone call that he made to the U.S. attorney and asked Mr. Jackson about that. And so he had limited. He didn't ask for a blanket discussion from the judge to ask if everything Alessi said would they vouch for. And I think
did you see that Brennan made a big deal of their response, the defense response, where they, again, I think as recently as this month, said that ARCA experts had not been paid, and they were, and he said, "See, it continues, Your Honor, it continues."
And that's why he's right. Yeah, we're going to be hearing a lot of this, and we're going to be talking a lot about this opinion when it comes down, I'm sure.
Yes,
because it affects so many people. Schmidt asks, change in regime will likely keep Menendez brothers locked up. That could possibly be true, because you remember John Lewin, who we're going to talk about next. Who the prosecutor in there, who was the subject of a biting, let me put it this way, a biting headline. Let me read it to you. Disgrace yet still employed prosecutor John Lewin's ASAP Rocky trial meltdown because District Attorney Nathan Hochman's first major media disaster. Now, Hochman's been on record saying that he would not agree to a new trial for the Menendez brothers. He was all over that, yet whether they get out of jail early is up and coming. But John Lewin has been accused of retaliating against the prosecutors in that office who were supportive of the Menendez brothers getting out of jail. And they apparently have taken steps to file suit against him and possibly the office for retaliation.
Your Honor.
The question I asked was but the question I asked was right, or
Your Honor.
Yeah.
So,
right.
Objection, motion to strike everything after the no.
Yeah, I mean, I'm sorry. I took something down that I think the producers had put up, and I apologize. I apologize for that. So this article, John, once a respected name in high-profile prosecutions. Well, really, he's only had Durst. I mean, because we had OJ, we had Specter, we had Robert, who was the guy who allegedly killed his wife, the TV show, famous actor. I mean, he had a lot of whatever.
Yeah.
And I don't think I've ever heard his name before Durst. Remember he was in the Cole case unit. He had Durst, and then of course you get gifted the Jinx, right? It's like wow. And then he becomes a fan favorite, because you're against somebody who's local,
right?
Yeah, Robert, whatever. But Lewin's trouble goes far beyond the ASAP Rocky question. His professional conduct has repeatedly called in question, this article says, with multiple allegations and legal challenges casting doubt on the ethics and credibility. You can go find this article. Yes, there you go. You can find this article
I can't take
online.
credit for it. Your producers came up with that right away.
Oh, okay. Oh, that's good. That's
okay. So it's a big deal. And I thought when the prior regime, did Lewin get sort of benched in the prior regime?
What happened is he was benched under Gascoigne.
Give us the gossip here, Linda.
No, it's not gossip. When I was looking at this, because what happened was there was an article, actually in the National Enquirer, of all things, a couple of weeks ago. But they were right. They talked about the Ninth Circuit case where the Ninth Circuit said that the only reason, or one of the reasons why a person was convicted was because of an outrageous misrepresentation made to a jury in a murder case. And Lewin, by the way, said that's not true. Arguing with Judge Arnold, arguing with actually Joe Tacopina when they were arguing the motions against. Lewin argued. If you recall, we had 3 scoops in this case, and somehow Lewin argued that Tacopino had violated the gag order by refusing to answer a question I asked him in our interview that we had right after the trial for everyone to see. And he didn't answer the question. So Lewin brings it to the attention of the court and I didn't even know about this until later on in the day, because it hadn't been broadcast live. And then he complained about me without mentioning my name. I guess he didn't want to mention my name on it. But but in that diatribe, I will call it, he said something about
one more comment.
Tacopina said something, and then about the Ninth Circuit and the outrageous misrepresentation. He said that's not true, even though the court reversed the case. He was the prosecutor, and because of an outrageous misrepresentation the prosecutor made. And then there was an appellate lawyer, apparently Alan Yokelson, who's also in this argue, and basically, argues that basically Lewin's an egomaniac and he manipulates, and he thinks that he does anything he can to win. Calls Lewin. Says he makes a mockery of justice, and that this now gets reported on not only by the National Enquirer but by this new publication. Somehow, when I printed it out, you have the name of the publication there. Current, was it? I printed out the.
Can I tell you something which is interesting about this?
I cut off the name of the publication.
So this is so interesting, Linda. I'm so glad you brought this up. So in Durst, he was the hero, right?
Right.
He was the hero in Durst. He got away with everything in Durst. Jurors laughed at his jokes. The judge took their lead from him. He got to cross-examine Durst for, 40 days and 40 nights or whatever long the cross-examination was.
It was long, long.
And in this day, and the judge finally in Durst goes, look, you're not going to get a straight answer out of Durst. So you can keep going, but you're not helping anything. Here, John, he went. Now you've got you've got a defendant that people generally liked.
Right.
And a defense lawyer that people generally liked. And the same tactics didn't appeal to the jurors.
And a couple of witnesses, like 12B, the kid, was sued and talking to the jury, and do you feel me, right?
Yes. I really can't feel you now, sir. You understand I'm not able to answer whether I can, that there's just, Your Honor, but Your Honor. Well, let me ask you this question, Ms. Baden. So I'm going to put to you this question as a hypothetical. Isn't it true, I want you to imagine that everything you said up to this point is a complete lie, and
I know, right?
I even messaged you. I don't know if I don't know if I can disclose this, but it's kind of funny. I was just like, the judge actually said that Lewin's the best cross-examiner he ever saw.
I know, it's okay. Like what?
One of the things that I thought was great was priceless.
Hypothetical that you're. Let me assume, Neil, it's hypothetical that everything you just said is a lie. Now, would you answer my question?
Yeah.
Oh
No.
my goodness gracious!
Motion to strike everything after the word no.
So we're going back to the Glossip case and the Karen Reed case, and here you have the Glossip case now says if you have a witness that lie, you as a prosecutor have to get up and say the witness is lying. And ASAP Rocky, that would have put an ethical duty on Lewin to get up there and say, but he's going to say, I don't believe he's lying. But you got to tape that tape with the blackmail.
It puts an obligation on both. It puts an obligation on John, and it puts an obligation on the other prosecutor. It puts an obligation on any prosecutor. It just puts an obligation on a prosecutor. And I don't like the idea if you call a witness and the witness is up there saying, watch this video. Well, that's not me. Well, okay, I'm going to spend the next 15 minutes of court time proving that was you. Okay. Right. Maybe it was me. Well, as opposed to going through all that, just, you stand up in there and say, sir, that's not true. You just told us it wasn't you. And now imagine if prosecutors, and I'm not going to single out John just for this particular moment, but just imagine what would happen if prosecutors stood up and started doing that.
Oh my God.
In the middle of trials, just saying that's not true. I have
well, let's take it back to Karen Reed, right? It's an ethics violation because you didn't do that. Where's the ethics violation here? Why aren't we talking about that in these cases of prosecutors?
Do you want to know how cleaner the legal system would be if the prosecutors had to get in there again and stand up there and in the middle of a witness's testimony and just say, excuse me, Your Honor, I need to approach for a minute. Say the witness has said something that I know that isn't true. And citing this line from the Glossip case.
Let's say it again.
A lie is a lie, no matter what its subject. Your Honor, I got a duty to stand up here and tell you that what the witness said isn't true. Now, is that going to help your case? No. It's not going to help your case. Is it going to help you? Is it going to help the legal system? Hell yeah, it's going to help the legal system. Because now we're going to have when a prosecutor says my witness was being truthful, now guess what? Now you've got some credibility, some history behind you. And I want to say, I thought I would have loved to have seen, because I think that Joe Tacopina looks like he spends a little bit of time in the gym.
I think we asked him about that. Yes, he says even during the trial, he exercises 45 minutes a day.
I would have liked to have seen that, And
in this corner we have.
Yes. Because it kind of it looked like it was about to come to blows a couple times, didn't it?
Oh, it's certainly, Tacopina was like with the crying eyes. And then he said, oh, you scare me. I mean, trials are supposed to be entertaining, but this was not a murder case, so it felt entertaining.
Yes, and because oddly enough, it did. And then but the stakes were so high for Rocky. He was looking at how many years? He was looking at
24. 24. He could have. The state said they were going to be good, and not spend him.
And I want to tell you something.
And
I'm going to say this
something.
to your audience. I'll say it to everybody that anybody and everywhere. If some prosecutor, I don't care who they are. Okay, I don't care if it's the top prosecutor in the country, down to the newest prosecutor who's afraid to try a case against someone like you, Linda. If you and I were trying a case together as defense lawyers, and some prosecutor came over and wanted to talk to our client's family about a potential plea and how you ought to rethink it, I'd be like, fuck off.
Right, and that's what apparently he did.
I'd be like, fuck off.
Apparently he did that in a number of cases, according to that article. And he went over to I think the mother and the sister of ASAP and said something too, didn't he, on this about like, I'm just doing what I have to do or something?
Like, don't come over. Can I do that? Yeah. Can I get that? Can I do the finger in the F off thing, or is that like?
Yeah, you can. We are not subject to the FCC regulations.
So how dare you? Because we end up as lawyers, we represent a client, but as you know, we end up representing. We spent time talking to the family. Right. The family has to trust us too.
Right.
You don't represent someone like ASAP Rocky, and in the meantime have the entire ASAP Rocky family, Rihanna, his mother, his sister, everybody else, hate you.
Right.
We have to appeal
Right.
to his whole family, and they have to trust us. And you're going to come in now and tell us, you're going to, oh, sure, prosecutor can go over and just sit down and talk to my client's family and tell them that, that we're making a big mistake. The hell with that. Know your place, man.
No, I tell you what, it's there's some things that I would, if I were a supervisor, and I have been a supervisor, and you've been a supervisor prosecutor, you tell your people not to do.
I have not been.
Tell your people not
I
to
was
do.
just a line prosecutor. So
Okay, all right.
I did special cases, but I supervised one, me. So
well,
that was it.
But if you're more, I used to laugh because people come in and want to look at file. That I just open my file. Here, you want to see my file? If you have anything here, just have it. Go. Here's the conference room. Go. Here's the box.
I can tell you this as a prosecutor. I never walked over to a defendant's family and said to them, "This is a deal you ought to accept."
No,
and
absolutely never.
That you ought to convince your son to take. So no way, no way. And I would like someone like Dave Portnoy to come along as one of these backyard brawl things. They have like these. Or Dana White. I want to see. I'll buy it. I'll buy the pay-per-view of Lewin against Lewin against Joe.
Yeah.
Now I know that's probably not a fair fight, but we'll let John pick a partner.
Well, we're gonna have our same questions to Hochman's office that we asked, about the ethics issue that we tweeted at them, and they haven't answered. And we're quite frankly, I'm waiting for. Hopefully, I want to know when the sidebars of usually the sidebars come out later. I don't know whether they're sealed or not sealed or when they come out, but we could file a FOIA request, and we're going to ask them to come on the show. We're going to ask them to come on the show because and discuss it. Let them come on. They want to argue with us.
And there were a couple of reporters that were challenging that story.
Yes.
At least one.
There was one who had to take a different, and I think Joe at the very end said something to her. And what got me is that somebody else retweeted it as if we wouldn't have sources. And I've tried a case in that courthouse. I was there for 6 months. John Lewin's been there for how many years? He may have enemies of some of these people that that Yokelson talked about. I mean, to doubt our reporting, which was right. We reported first that there was going to be a shakedown argument by the defense, and we had the number right, 30 million. We were a little concerned about that initially, and then but then it got sourced again. And so when it got sourced twice, we went with it. And sure enough, the defense opened up with that. So we were pretty sure of our sources at that point. And we reported again that the judge did inquire the prosecutor about ethics of going forward, or some words to that effect. We don't know the exact words, but that was the realm during Relly's testimony, and then inquired again the next day about whether they were still going forward, given Relly's disastrous cross-examination. And you know what? And some reporters said the reporter said the judge said that we were wrong. Never. That never happened. Not only did it ever happen, you notice when John Lewin argued that Joe Tacopino violated the gag order and suggested that our sourcing wasn't correct, he never denied that existed. He never denied what we reported. Then there was never a denial. All there was that Joe Tacopino violated the order, right? The gag order.
So one of the things that bothered me, again, I'm going to go back to this quote from the Supreme Court opinion. A lie is a lie, no matter what its subject. I had a trial in which a witness during a preliminary examination was not truthful about whether he had used cocaine. And the reason he wasn't truthful, according to him, he said no, he did not. And the reason that was an important piece for us because we had this testimony, and I called that a fence post. That to us was a really sort of a fact that was beyond change. He testified to it at a preliminary exam, under oath, was unequivocal. I did not use cocaine at this person's house, had not been given cocaine. We're like, done. Okay. Right. All right. It should be, I'd not used cocaine, period. Done. Right. He comes to trial and he testifies that he had used cocaine.
Oh.
And I'm like, we go through the setup as you would, right?
Right.
The
Right.
oath, under oath, raised your hand. Here was the question. Your answer was, and I mean, you lied. He admits it. Like, that's perjury. He admits it. Then he says, the reason is that my dad was in the courtroom at the time that I testified at the preliminary exam. So you're apparently, now was he ever charged with perjury? He was not.
No.
Was he ever charged with lying under oath? He was not. But apparently perjury or lying is acceptable in the eyes of some witnesses if they have a reason for it. And one of the things that troubled me in this case, in the ASAP Rocky case, was just that there was an attempt to explain why Relly got so upset about his girlfriend in that picture. And as opposed to, yes, he wasn't being truthful, he wasn't being candid, or it was the argument from the state was, as I recall, and you might recall better, but was something like, could you imagine that, he's unpopular now, he's going up against one of the biggest stars who's married to even a bigger star. Right. And now she's going to have your girlfriend or whomever exposed to the public in that way. And I think to myself, okay, but going back to the Glossip case, again, a lie is a lie no matter what its subject.
Yep.
And when we get to, and so that's one of the things that bothered me, is that prosecutors, you can get up there and just, during Karen Reed, we saw it, where prosecutors were just, witnesses would say something, and then,
the Proctor factor.
I didn't.
Michael calls it Michael Bryant. Michael calls it the Proctor factor. So
I did do it. Yes, I did do it. And then, okay, oh, you know what? I didn't do that.
Yeah. So anyhow, we have, thank you, Neil, very much. We have a lot of chatters on. I know we had more, probably someday making dinner, but all of you, could you please like this while you're here? Neil is donating a lot of his time to answering your question. We know he's a fan favorite. I'm sorry we went longer
than an hour or two.
No. I asked you whether or not you could stay on longer, because I know you're a fan favorite, and I thought that the cases and the issues we were discussing were important enough to bring them up. And we have a lot of people that are waiting for you to come on. As you saw, it was
you know what?
It was a busy time.
You and Michael both have big shoes to fill, although yours I probably couldn't wear because they're
mine are a little, they got a little heel on them. No, you definitely could wear them to court. No, I can't even wear the shoes I'm wearing tonight.
I couldn't afford.
Yeah.
And anyway.
Yeah. Anyhow, so no, and I also want to tell you all that Michael Bryan had a couple other clips that we didn't play. He asked Karen Reed a question. He asked people around the question, and we're going to play this because he was one of the few people that are following this that were in Canton. So remember, we were there, and so when we give you that reporting, it's because he was there at the courthouse. And
I think you guys have shown that you're not, and neither is Michael. I think you guys are like me, students of the game. I mean, I'm gonna call it a game because it's a
we're students of the
students of the art of the
art,
and not picking sides. We've had cases where we thought the defense did a pretty crummy job, and cases where we thought that the judge was doing a terrific job.
Right.
And I think that you guys have done a pretty good job of calling balls and strikes, and that's a case that obviously has drawn. You've got people on both sides of that case, and it's good to see Michael out there trying to, get some answers. I mean, he was putting questions to AJ that were maybe not.
They were tough questions, right?
Those weren't soup questions.
They were tough questions, and no one else was asking them. We were, that's what I said. We try to when represent our clients is one thing, but Michael Bryan
you're always one of my favorites, as you know.
Yeah,
anytime
I appreciate
I'm available to step in for one of you guys, and I You've become my go-to watch. So
We'll have to
best
have you
to-
on more because
best
everyone
to
here
you and
just loves you.
Michael. And to be or not to be.
To be wants to go outside now. To be is
I
like,
bet
you know,
you.
I've had enough of this. I want to go to bed. But you
Right.
know what? I have to say,
Tell
you
me.
know what Michael Bryan's tagline is? You know his tagline
The legal
is
edge.
try to do the right thing. And so with that, I will say thank you, Neil
Appreciate it.
Rockind Neil, as
I
I'm
know.
calling you, for coming on, trying to do the right thing.
I appreciate
Again,
it.
if you like Justice Served TV, please hit that like button, subscribe, share, and the notify button. And we will see you again. Thank you again for being
Ciao,
with us
everyone.
for near 2 hours. See you tomorrow night.